This is Advocate Lucinda, your empowerment lawyer. You know, one of the most difficult things about litigation is the depositions. Some of you have experience taking depositions because you shared that with me. And you shared with me how difficult it was because the opposing counsel was difficult. Now, this video is not to bash opposing counsel because as attorneys in depositions, we do get aggressive because both sides want to prevail for their client. But when aggression spills over into belligerence, then that's a problem. So this video is about how to navigate a difficult and sometimes belligerent opposing counsel. So I give you 7 tips. You know what? In the end of this, particularly for pro se litigants, this will help your mental health. I'm finding that mental health is an issue with a lot of pro se litigants because it's a lot up on them. So these days, I'm thinking of the pro se's mental health. I understand how litigation can affect one's mental health, and especially when an opposing party is difficult or belligerent, it can really affect your mental health. So this is to help you navigate through a difficult deposition. At the time of the deposition, you will know the attorney's temperament. And that's important, knowing the attorney's temperament. And so you want to deal with that attorney according to the knowledge that you have about that individual. Tailor your responses to opposing counsel according to what you know about opposing counsel. For example, if you expect opposing counsel to yell at you or call you out your name, and these things happen, you may want to contact opposing counsel before the deposition and have a talk. If you know that opposing counsel gets belligerent, out of control, you may want to let opposing counsel know, listen, if this happens during the deposition, I will have to write the bar and report you because your conduct is deviating from the standard to which you have to conduct yourself. But make sure at all times that you respect the opposing counsel. Even when opposing counsel becomes belligerent, you maintain your posture, you be the bigger person in the room, and then do what you have to do later to address that. If at any time the deposition become hot and heated, it begins to affect your mental health. You just say to opposing counsel, listen, I would like to take a break, but take advantage of that break and calm yourself down. Okay? Certainly know the rules regarding depositions, and you can find those rules at Federal Rules of Civil Procedure 30. If you can afford it, have a recording firm videotape the deposition. Ask the company providing the deposition services if they can videotape the deposition, because the purposes of the deposition are to gather evidence and impeach witnesses. A jury may find a video of the witness contradicting themselves more powerful than just a statement. So having the deposition recorded enables the jury to see the temperament of the opposing counsel. So a hostile and belligerent opposing counsel is not going to look good in the eyes of a jury, and it will not look good in the eyes of the judge either. You could audibly record the video, but to be safe, you can be sure to read your jurisdiction's rule on whether you would be allowed to record. In fact, have ready to present to opposing counsel the civil procedure code that permits you to record. I have seen often is opposing counsel insisting that a certain law prohibits you from asking a certain question to the deponent. Hey, if you're not familiar with that law, just ask opposing counsel to provide that law to you. Opposing counsel give you the law and take the time to read it to ensure that that is in fact the law. Another thing, per se, you can say to opposing counsel who is belligerent, and because of his or her belligerence, the deposition is at a standstill. Let the opposing counsel know that if this continues and it is not justified, that you will file a motion to compel and ask for sanctions. But you want to be sure to read the federal rules concerning the motion to compel and sanctions and any local rules. Or you can stop and call the judge and say, Your Honor, opposing counsel is being very difficult, hostile, belligerent. Make sure that's the case now. And that because of his or her conduct, the deposition is at a standstill, or whatever the situation is. Now, make sure that the rules, local rules, would require you to contact the judge. I've done it years ago. I've only had to do it once that I can recall. It made a difference. Let me say this too. Consider if your jurisdiction permits bringing someone with you who could be a support, a pastor, or someone who gives you spiritual guidance. Check out your local rules and determine if that's possible. Because whether you are being deposed or you are deposing someone, it takes courage. And sometimes you need a little help. So that is an option if your rules permit. Okay? I trust this has been helpful to you. And as always, I'm Advocate Lucinda, your empowerment lawyer. Take care.